All right. Welcome, everyone, to our Civics 101 session. This is going to be a lot different than a typical bonfire. It's going to be interactive in a different way. Since there's not going to be as many of us, we don't need to just be chatting in the bonfire chat. You're going to be able actually to unmute yourself. You can go on camera if you want to, but you don't have to when you want to ask a question. So what I'm going to be doing is going through the basics of Civics 101. I've given this session many, many times, delivered it to adults, delivered it to high school students before. And the goal of it really is to give you all of American politics in 60 minutes or less, all of the basics, everything you would need to know. It's ambitious. There's going to be things that are left out, but we're going to try our best. And what I'm going to do is after I go through one of these areas, after I go through a slide, I'm going to pause and I'm going to see if there's any questions on that slide. And you can either put your questions in the chat or you can raise your hand and I'll call on you to say your question on camera or off camera if you want, if you just want to turn on your audio. So if that sounds good, we will get started. Oh, also, I will send out these slides to anyone who wants them. So don't feel like you need to take notes on this or anything. I'd rather have you be listening and thinking about questions rather than like trying to take down notes. All right, so let's get started. On our agenda, we're going to talk about first what are called constitutional underpinnings. This is how our system of government developed. Second, we're going to talk about the three branches of government. So legislative branch, we're going to focus on how a bill becomes a law. Executive branch, we'll focus on what are the president's powers. Judicial branch, what does the Supreme Court do? And then we're going to look at how these three branches interact, the separation of powers and checks and balances. Then we'll look at the Bill of Rights, the first 10 amendments to the Constitution, and then the other amendments. And then finally, we're going to look at political parties, interest groups in the mass media, how they fit in, and then our shared political culture and beliefs. So let's get right to it and talk about constitutional underpinnings. This is important to know what's underpinning our constitutional system, our government. First thing to note is that the Declaration of Independence in 1776 started the revolution in America, but it didn't say anything about how to run a country. It was literally a declaration of independence. It was not a document that was meant to show us how to govern. The framers' first attempt at doing that, their first attempt at governance, was called the Articles of Confederation, and it failed. It was a loose confederation of the 13 colonies, and there was really no national government. So very, very weak, and it didn't work. It failed. The framers' second attempt was much more successful because that's what we still have with us today, and that is our Constitution. It's been around since 1789. People like Madison, Hamilton, Jefferson, Adams, these names you may have heard as kind of the most important framers to the Constitution. They looked back to the Enlightenment period, to the early 1600s in Europe. They looked back at these thinkers when they were writing the Constitution. They didn't just come up with this stuff out of thin air. Sometimes they even look back as far as ancient Greece and ancient Rome, but they were really inspired mostly by Enlightenment thinkers. People like Thomas Hobbes. Hobbes is famous for writing a book called Leviathan. You may have heard of that book and you probably will read it if you want to do political science in college. Hobbes says that in the state of nature, before we have any kind of government, it's pretty dangerous out there. People can just kill each other if there's no rules in this state of nature. And so he says what we need and what we all enter into when we enter into a society is a social contract, meaning we give up some freedom. We give up the freedom to kill each other in order to be protected. And that's not an easy thing to do. But everybody that lives in a society has bought into this social contract. Even though you've actually never signed it, you have. And the framers were really influenced by Hobbes's thinking here. Second, John Locke, one of the most important Enlightenment thinkers. He was the person that came up with the idea of life, liberty, and property. Thomas Jefferson basically took that phrase verbatim when he said life, liberty, and the pursuit of happiness. Sorry, just gonna let this person in. Okay. And then next, third, is Baron D Montesquieu, a French Enlightenment thinker. He was the first one to think about splitting government into 3 branches. So it wasn't James Madison that came up with that out of nowhere. It was an Enlightenment thinker. So the result of this kind of thinking was a constitution that embraced the following ideals. 1, popular sovereignty. This means power to the people. They didn't want to be ruled by a king. They just got rid of a king in England. 2nd, the rule of law. You probably hear a lot about this right now. It's a very common phrase that political commentators use. The rule of law means that no person is above the law. It applies to everyone. It applies to the members of Congress. It applies to the president. It applies to the richest people in society. No one is above the law. We're governed by laws. 3rd, limited government. We believe that government should not be all-encompassing. Again, that's why we don't have a monarchy. It's why we don't have a king. 4th, we believe in the separation of powers and of checks and balances, which we're going to talk about more later on. 5th, federalism. Federalism, we're going to talk more about in a second as well. This is the idea that you can be governed by more than just one government. So if you live in the United States, you're governed by the national government, the federal government, you're governed by your state government, and you're governed by a local government. And so that's kind of a crazy idea to have 3 governments, and how do they interact? That's this idea behind federalism. So I'm going to pause right there and see if there are any questions on constitutional underpinnings before we get to talking about federalism. And so if you have a question, you can raise your hand, or you can turn on your camera and ask away, and I'll wait 15 seconds to see if there are any questions.
Well, may I ask a question?
Yes, please do.
So federalism idea is about autonomy to states, right?
Correct. So states have autonomy to govern their citizens, yes.
And this started with the Greek polis, right?
Correct. The Greek polis, correct.
So this idea of federalism in the Constitution was something that they took inspiration from the Greeks.
So you're right. The Greeks didn't have a national government in ancient Greece. They were polises, which we consider like city states, and they would sometimes go to war with each other, right? Like Athens and Sparta. And so you're right that idea of having a local or state government, yes, that does trace its roots to ancient civilizations like ancient Greece. What was new was having to unite those under one federal government. There were Greeks that tried to do that as well, obviously like Alexander the Great, and then the Roman Empire, you could say, was almost like a federal system. But what was unique about this American experiment is that there were 3 tiers to it, which I'm going to show you actually right here, because your question relates to this. So in a federal system, there are 3 layers of government: a federal, state, and local government, all at the same time are governing. Now, the Constitution makes clear that in the supremacy clause, there's a clause in there that says that if there's a conflict between the federal government and the state government or local government, federal law always wins. And you can see that some of the most important powers are given to the federal government. For example, creating money. Under the Articles of Confederation, under the old system that they created at the beginning, different states had different currencies, and that was a disaster. There wasn't one unified currency. And so it took the national government creating that currency to start unifying things. Having an army, right? Again, before the Constitution, each state had their own militaries. That wasn't very organized. And so if the US would want to go to war, it would need to unite all of those collective armies. So instead they thought, let's just have one army for all of us, making foreign policy. Imagine if you had one state, say Massachusetts, having a different treaty with a foreign country than another state like Virginia. That was possible under the old system. Constitution says, no, no, no. We have one national government that's going to make foreign policy for the entire country. Now, on the other side, you can see that some important powers did stay with the states. So, for example, the most important power that states might have is conducting elections. There is no national structure for how to do elections. Some people think that's a big mistake, and we should nationalize elections at this point. And we'll talk about elections a little later. But it's fascinating that each state can have different rules around elections as long as it doesn't violate the Constitution. And then issuing permits and licenses, right? You can get a state driver's license. There's all kinds of powers that are unique to the state. And then right down the middle, concurrent powers are powers that both governments share. So if you or your parents pay taxes, you know that you have to pay both federal and state taxes. Some states have zero taxes. They can do that if they want, but a lot of other states have taxes as well. And then building roads, that's really important that we have federal highways and we have local state roads. And then finally, making laws. This can get confusing because the federal government has their own set of laws and then state governments have their own set of laws. And sometimes they can come into conflict. The framers believed that if they did come into conflict, the national law, the federal law, was the one that reigned supreme. So I'll pause there again if anyone has any questions on federalism.
I just had a quick question real quick. Do the state taxes actually go to the national government?
No, they stay with the state. Great question. And so then the state can use it for whatever they want.
So the state taxes, they don't have to give the government anything.
Correct. So what state do you live in, out of curiosity?
I live in Arizona.
Yeah, so the Arizona collects taxes and then they can use it to fund colleges. They can use it to fund schools. They can use it to build their own roads, all kinds of things that they can do in Arizona. They don't have to, they don't send it back to the federal government. Good question. If you have your hand up, go right ahead.
Yeah, so I live in Ohio, and this is, I guess, sort of one of the things I was wondering about, which is, I know there is some form of, I'm not sure what the term is, but I believe it's equalization, whereby money from the richer states flows into the more economically disadvantaged states. Is that only done through the different federal taxes that are levied, or is there any sort of state transfers, I suppose, through the federal government?
Yeah, no, you're 100%. What the first thing you said is what's correct. The state itself. So Ohio doesn't send money to the federal government. What happens is the federal government taxes people in Ohio, takes that money through federal tax money, and then has national programs that redistribute that wealth to maybe a state that didn't pay much taxes. So for example, Vermont, right? Vermont is a small state near where I'm from, Massachusetts. And so the people in Ohio are definitely paying more taxes than the people in Vermont. And the people in Vermont might benefit from that, from federal programs, potentially a welfare program or a food stamps program. Does that make sense? But it's not the state of Ohio sending money to the federal government. It's the people of Ohio getting taxed.
Yeah, of course. Thank you.
Yeah, no problem. And that's why, some states come out ahead with federal taxes and some states come out on the other side. Ohio is definitely a state that pays more taxes and then they essentially get back in federal government services. Any other questions before we move on? These are great questions, by the way. All right. So let's talk about the three branches of government. First is the legislative branch. And there's a reason we start with the legislative branch. And that's because that's what the framers started with. Article 1 in the Constitution, the very first article in the Constitution, established a legislative branch. And that was not a coincidence. The framers did that on purpose because they wanted it to be the most important branch. If you read the Constitution, there's way more written about the legislative branch than the executive and the judicial. There's barely anything written about the judicial, which we'll talk about. And so they wrote this to try to stress the importance of the legislative branch. What they created was a two-tiered system, two houses of Congress they created. First is the Senate. The Senate has 2 senators from each state. Very, very simple. And they serve 6-year terms. Now, this helps smaller states, right? So let's go back to our example between Ohio and Vermont. Ohio and Vermont both have the exact same number of senators too, even though Ohio probably has 10 times the people of Vermont, but the Senate is equal. Every state gets 2. The House of Representatives, on the other hand, is proportional. It's based on the state's population, and House members serve for 2-year terms. So Ohio would have many, many more representatives. I don't know off the top of my head how many Ohio has, but I'm guessing it's a lot more than Vermont because Vermont only has 1. Now, the reason that this was established was because the big states and the small states couldn't come to an agreement on what the legislative branch should look like. And they had to come to what was called a great compromise. It appeased both big and small states. Many people now think that we should reform the Constitution to remediate this. They think that now that we have 50 states, and many of those 50 states don't have that many people in them, some people think it's unfair that a small state like Vermont gets 2 senators, while a huge state like California or Texas also only gets 2 senators. That's something that you should definitely be thinking about, whether you think that's fair, or whether you think there could be a better way to do representation. Now, what areas can Congress make laws in? People are wondering, like, what is Congress supposed to do? Well, they can make laws about pretty much anything. This was decided early on in a republic due to what's called the Commerce Clause and the Necessary and Proper Clause in the Constitution. Congress can make laws pretty much about anything. The reality of Congress is that most of the work gets done in committees. It's not individual senators or individual House members that are writing bills. They have huge, huge staffs, and they work on these committees together to get stuff done. There are a bunch of different types of committees. The most important ones are standing committees. These are the ones that are permanent. Some of them that you might have heard of are the Rules Committee, the Budget Committee, Appropriations Committee. Then there are what are called select committees. These are special temporary committees to conduct an investigation. For example, there is currently a special committee that's investigating what happened on January 6, 2021. Third, there are joint committees. These are committees that are made up of both House and Senate members that are permanent. And then finally, there's something called a conference committee. This is a special temporary committee that's made up of both House and Senate members when they have a disagreement over a bill. So I'll pause right there. That's a lot of information. This stuff at the bottom is pretty advanced. You probably only get to that if you're taking like an AP US government course, or you're taking an intro to political science course in college. But the info above that is essential kind of basic knowledge about the legislative branch. So if you have questions, feel free to chat them out.
Who decides like who gets placed on what team?
Who gets placed on which committee?
Yes.
The leadership of each political party. So right now, for instance, the House of Representatives is controlled by Democrats, the Democratic leadership there. They get to assign people to the committee. So they essentially get to assign whoever they want. And now the Republicans, they have a minority leader who also gets to make assignments to committees. And so it's through the leadership.
Okay.
Good question. If you're a young senator or House member who has just come to Congress, you don't have a lot of say in what committee you want to be on. But the longer you stay in Congress and the more senior you become, then you have more say in which committees you are assigned to. Any other questions before we move on?
I ask, because I know you talked about, you touched on this, of how like it's huge staff that each representative or senator has. So this is something I've always sort of wondered, if it is the staff who's actually doing all of the physical writing, then who is it who actually physically decides what the bills and what the legislation will look like? If like, are the ideas coming from the staff who write it, or are they coming from the representatives themselves?
Yeah, great question. They're coming from the representatives. I mean, that's the idea. It ultimately falls on them, and they essentially tell their staff what to do and what to write. But I'd be lying if I told you it sometimes doesn't work the other way. They have to rely on their staffs to do the research for them too, to tell them how they should vote on certain bills, to tell them the right way to think about these things. And so that's why the staff has a really powerful position. They're not just like people that get on a computer and start typing away, and kind of the House member or senator dictates to them. It is more of a reciprocal relationship.
So if I could follow up on that, like what exactly does that look like then? Because I know for like a lot of bills, they require like specific listing out of items, for example. Maybe there's a bill on drugs, or a bill on prohibited substances, and there needs to be like individual things that are listed out. Surely it can't be, for example, the representative listing out all of them and then telling the staff to write them, right?
Correct. And look, it's not a perfect system. This is how things get in bills that might get overturned eventually by the judicial branch, which we'll talk about, because like you said, there might be like a bill around a narcotics bill, and like you said, there might be a list of like quantities or percentages of certain narcotics that are legal or illegal, and a lot of that comes down to kind of compromise between people who are writing that bill, and it might not work in practice. Like this is last night was a lesson on systems thinking. Sometimes Congress doesn't do a great job of systems thinking, and they might not have fully thought through the consequences of what they're putting in these bills. And so it's definitely an imperfect system, and sometimes they're working under real pressure to get these things done, and these bills are hundreds and hundreds of pages long, and so you find things in there that don't make sense. And so that is go ahead.
Sorry, I'm so sorry for taking up the time, but so does that mean that effectively like each bill is a compromise? It's not necessarily like a representative's true ideas, but instead a compromise of all the collective minds in the staff and the people who are writing the bill?
100% a compromise. And so I want to show you what the process looks like. Okay, so here's a simplification of how a bill becomes a law, but it's going to illustrate how this compromise needs to happen. So when we're thinking about a bill, somebody first needs to come up with the idea of it. Then that bill needs to be introduced to either the House or the Senate. It can really start in either place. It usually does start in the House of Representatives, but it can start in either place. Then it goes in to a committee. It goes into whatever committee is assigned to work on it. And so all those staffers there could be 50 of them, and those representatives, they work collectively on a proposal. And so they're writing the bill there. And so it's a collective effort. Then they bring that to the full House, to all 535 members of the House, and then they vote on it. If they vote yes, okay, great. Then we're going to move it over to the Senate. If they vote no, then it can go back and they have to work on it again until they get enough support for the bill. If there is enough support and they vote yes, then it goes to the other House. So then it would go to the Senate. Now the Senate has to go through the same process. The committee in the Senate is going to review this bill. They're going to see if they want to make changes. And if they can't agree to it, then it will go to what's called reconciliation. And then you'll have members of both the House and the Senate working on this bill together over many, many late nights. If the Senate then finally says yes, then they send it on to the president. And at this point, the one person, the president, can decide to veto the bill. They can say, no, don't like it. Even after all that work, they can veto the bill. Or they can say, yes, I do want to support this bill, and they can sign it, and then it becomes law. But you can see that at so many points in this, there are avenues of collaboration, but it also means that a bill can get watered down, right? Because it's a product of so much compromise. Does that give you enough color of what you're asking about?
I mean, like, for example, in one of the small, like in any single step, even if it's one representative staff, because certainly there's collaboration and compromise between different parties, but like maybe within one entity. Does that make sense?
Oh yeah, it does. And there is definitely collaboration and compromise within a staff. I mean, think about like a team that maybe you've worked on or a club that you've been a part of. And even if there's only 5 or 6 people working on something, there tends to be different views on that. And so, yeah, each staff is going to sometimes have battles over which way to go on things. It's not apparently obvious. People are usually pretty ideologically aligned. Like if you're going to work for AOC, you're probably pretty aligned to her politics and on her staff. But it doesn't mean that you think exactly the same as everybody else on that staff on every single issue. And so there's definitely going to be contentiousness sometimes, and that's going to have to result in compromise amongst the staff. But the representative is the one who has the final say, obviously, but they do rely on their staff. Okay, so let's move on to the executive to see what powers the executive has. Article 2 is what established the executive branch headed by the president. The executive branch is huge, though. It's not just one person. It's just not the president. If you ever heard of the term the bureaucracy, that's what it's referring to, is all the government agencies that are in the executive branch. The president serves 4-year terms, is limited to 2 terms. Didn't always used to be that way, but it is now. If you want to become president, there are only 3 requirements. First, you have to be a natural born US citizen. You cannot become a citizen after you are born. It makes you ineligible for becoming the president. Second, you need to be at least 35 years old when you would take office. And then third, you need to have lived in the US for the last 14 years. So even if you are a natural born citizen, even if you're 35, if you have gone and lived in another country, you need to come back to the US or US territory and have lived there for the last 14 years to be eligible. The president plays many roles. Here are some examples of the roles the president is intended to play. First, the chief of state. This means that the president is a symbol to the rest of the world. Second, the chief executive. Like I mentioned, the president has the power to veto laws, very important power. Third, the chief administrator. The president is the one who runs the whole executive branch. The president gets to appoint the people that run departments like the Environmental Protection Agency or HUD, Housing and Urban Development, or the transportation. The president has that power. And so they can hire and fire all the people that lead those organizations. Fourth, and most famously, the president is commander-in-chief of the armed forces. The president has the ability to unilaterally use the military. This power has been called into question many times because there's a law that's called the War Powers Act that has tried to limit the president's power. Congress is the only branch that can declare war, but the president, as you have probably heard of and seen, often takes military action without consulting Congress. And this is something that's in a gray area. And it's something that has never quite really been resolved. And so, yeah, I think somebody might have a question about that.
Yeah. So what if like the president does something that like the entire Congress does not agree with?
Oh, great
Is there
question.
like a checks and balancing for that?
Yes. So we'll look at the map in a second of checks and balances, but that's a classic one. At that point, Congress, the legislative branch, can impeach the president. And then if they are impeached, there's a trial in the Senate. And if they are found guilty of whatever the offense was, then they can remove the president from office.
So this would all technically happen after the war, after he's done whatever wrong he did.
Right, exactly. So if let's say the president decided to launch an airstrike against an ally, against Canada, say that the president tries to invade Canada and the legislative branch is upset about that, they can't do anything in the moment. They can try, but they don't have the power of the military. What they can do is try to immediately impeach the president and then immediately remove them from office.
So the relationship with Canada is like forever ruined, though.
Right. I mean, well, it depends how severe the strike was. I mean, who knows
Okay.
what would happen in that case. If it seems like it was just, a decision made by a rogue, maybe mentally unstable president, then maybe Canada would forgive us, but maybe not.
Yeah.
Good question. Next, chief legislator. So this one's weird. The president's not in the legislative branch, but the president does get to shape public policy. The president can go on TV whenever he or she wants and say, I want Congress to do this. I want to put pressure on Congress to do this. So the president has this incredible power to shape public policy. Fifth, the president is the party chief. So whatever political party the president is part of, they are the leader of that political party. People in that party look to the president for guidance and advice. They kind of set the agenda. And then finally, the president is supposed to be the chief citizen of the nation. They're supposed to be the model for the nation. They're supposed to model good citizenship, what it means to be an American citizen. Okay. So actually, I'll go back for one. I'll pause there. Any other questions on the executive branch before we get to how the president is elected?
I could maybe tag on to the last question. Does this mean that hypothetically, if the president decides to unilaterally use the military to institute a coup d'etat of the government and have Congress sort of a military takeover of such, what would happen in that kind of situation?
Well, that's a scary situation. Obviously, the hope is that in a democracy, somebody would step in to prevent that from happening. So there is an amendment that allows for the vice president and the cabinet to remove the president from office if they're mentally incapacitated.
The 25th Amendment?
Correct, the 25th Amendment. And so that might be a good use of the 25th Amendment in that case, if that is something that can happen much quicker than impeachment and removal from office could. Also, in that scenario, the military would probably not follow the order. I know the military is supposed to follow that order, but if it were clear that the president at that time was using that power to try to overthrow the democratically elected government, then I don't know if the Joint Chiefs of Staff and the rest of the military would go along with that. If they did, then yes, we'd have a huge problem. Any other questions? Yeah, go ahead.
Yes, I was wondering what was the process of an impeachment, like how it starts, what the steps are followed.
Yeah, so it starts in the House of Representatives. It requires, it requires articles of impeachment to be filed. So you need to state your case why you want to impeach the president. And then you need 2/3 of the House to vote yes, that they want to impeach the president. If they do, then it goes to the Senate for a trial. The trial is conducted by the Chief Justice of the Supreme Court. And then all the evidence is presented as to why the House members are impeaching the president. And then there is a straight up and down vote. You need 3/5 of the Senate to convict, which is a pretty high number. And you do not get that, as we've seen through history. Presidents have been impeached before, but not removed from office. So it's very, very high threshold to actually remove the president from office. All right, so how's the president elected? We have this strange system in America called the Electoral College. Instead of just having a straight popular vote for who gets to be president, we divvy it up into what are called electoral votes. We have 538 electoral votes up for grab in a presidential election. To win, a candidate must get to 270 votes. That's the magic number. Each state gets assigned a number of electoral votes. You see the numbers on the screen, and that number isn't just something that is made up out of nowhere. It's based on how many House members and senators they have in total. So let's look at our favorite state of Vermont. I don't know why I'm picking on Vermont tonight, but Vermont has 2 senators and 1 House member. So that's 3. They get 3 full electoral votes. You'll notice that Washington, D.C., even though it's not a state, gets 3 electoral votes. So the result of this system, the effect this system has, is that it lets a few swing states, we call them. They are battleground states that they're sometimes called. They are the ones that get to essentially decide the election. And that's because even if a candidate only wins 50% of a state's popular vote, they still get all of the electoral votes there. And there are some states where it's virtually guaranteed that one candidate is going to win. So for example, New York, where I live, it's virtually guaranteed that the Democratic candidate is going to win. So nobody bothers campaigning there. And so even if there are 40% of people in New York who vote Republican, those votes don't matter. Those votes essentially get thrown out, and only the Democratic votes count, and the Democratic candidate gets all 29 votes. The same thing would happen in a state that's typically red. In Louisiana, for example, all 8 electoral votes are going to go to the Republican candidate. So neither candidate bothers campaigning there. They focus their efforts on the states that are 50-50, that are swing states. So like Ohio, Florida. Off the top of my head, I can't think of any others, but there are Wisconsin, Michigan, Pennsylvania. These are what have become the battleground swing states. Any questions on the Electoral College? Because I know this has been a big issue in the last few presidential elections.
On the local or the state level, are the politicians chosen through like a direct popular vote, or is there like another really complicated system?
So each state can decide how to have their own elections. They have that ability. For the most part, they are just normal popular vote elections. The senators actually didn't used to be elected popularly. The original Constitution had a kind of scheme like this for voting senators, but that's been removed, and now senators are elected just by a straight popular vote in their states. Good question.
How often does the amount of electoral votes a state has, like how often does that change?
Great question again. So that changes every 10 years with the census. So we just had the 2020 census. And so the electoral vote numbers are going to look different in the 2024 election than they did in 2020. There has been a migration, and this kind of pattern has held for the last 20 or 30 years. There's been a migration away from the northeastern states and into southern and western states. So every census cycle, it seems like New York or Pennsylvania or Massachusetts might be losing one seat or so, and then states like Florida or Texas or Arizona might be gaining a seat every 10 years. Good question. All right. Third branch, my favorite branch, the judicial branch. Constitution doesn't say much about it. First thing they do is say that there's going to be a Supreme Court. We're going to have a Supreme Court, and we're going to let Congress create lower federal courts. The Supreme Court justices, you might know this, you might not know this, but they are appointed by the president. There is currently a vacancy that's about to happen on the Supreme Court. Justice Stephen Breyer is retiring, and so President Biden is going to be able to appoint the next person that will replace him on the Supreme Court. He doesn't just get to pick, though, without someone confirming that pick, though. The Senate gets to vote on that. And it's just a straight majority vote. If that person passes through the Senate, then they are elected for life. They can serve on the court for life, and many justices do. Many have died while on the court, most recently Ruth Bader Ginsburg, and then Antonin Scalia before her. So there are lots and lots of rules about which cases the Supreme Court can hear, but I want to give you the basic requirements to get a case to the Supreme Court. First, the case involves a constitutional question. That's the simplest, easiest way to eventually get your case heard by the Supreme Court. So if it's a free speech case, if you were standing in a public park holding up a sign protesting against the government, if somebody from the government took your sign, ripped it up, and arrested you for that, that is definitely a violation of your First Amendment rights, and that involves a constitutional question, and so your case might eventually go to the Supreme Court. Second, the case is not a political question that should be left up to the legislature. The Supreme Court doesn't hear cases about tax rates, for instance. That's a political question. That's up to the legislature to sort out how high taxes should be. The judicial branch doesn't get involved in policy decisions like that. Third, the case is not moot, meaning it's not over. There's still an active controversy going on. Fourth, the case is ripe. So just like a piece of fruit, when it's ready to eat, it's ripe. When a case is ready to be heard by the Supreme Court, when it's worked its way through the court system, then it's ripe, then it's ready to be heard. Fifth, this is a hard word to pronounce sometimes, the case is justiciable, meaning the parties have standing, they have something at stake to be heard. Sometimes the Supreme Court will throw out a case if you don't have proper standing, if you're not the actual person that's being harmed. You can't bring a case for your friend, right? You have to be the person who's actually harmed if you're the one who's going to bring a case to the Supreme Court. Now, if all of these requirements are met, and if the court wants to hear the case, they will grant what's called a writ of certiorari, and they'll allow the case to be heard. You might be wondering how many cases they hear a year? Not very many. They only hear about 70 cases per year, 70 to 90 probably per year. And that number has actually been going down recently. They get appeals for thousands of cases to be heard, but they only hear about 70. So those are the basics of the court. We're going to look into the legal system a little bit more, but any questions on the basics of the Supreme Court and the judicial branch?
What are some of the most influential Supreme Court cases in history? Or recent influential Supreme Court cases? Wow,
that is such a great question, because I have a whole slide on that. So we're gonna get to that in a second. But I'm gonna start with the most famous, the first really important case that the Supreme Court ever decided, and that was Marbury versus Madison. And it's important because it established that the Supreme Court and any other court has the power to overturn laws that were made by the legislative branch. This is kind of the ultimate check, the ultimate balance power here. This power of judicial review was not in the Constitution. The Supreme Court gave it to themselves. Marbury versus Madison is a very complicated, complex case, and I'm not going to get into the details of it. If you go to law school, you will definitely learn about the details of it. But the only thing that you need to know is that Marbury versus Madison gives the Supreme Court the power to overturn laws that were made by Congress. So if Congress passes a law that they think violates the Constitution, Supreme Court is able to overturn it. Here's a really simple chart of how a case gets to the Supreme Court. We have on the left side is our federal court system. We have what are called U.S. district courts, then U.S. courts of appeals, and then the U.S. Supreme Court. And then on the right-hand side, you have state courts, you have state trial courts. Again, remember federalism, we have federal and state courts. Then we have intermediate appellate courts and then state Supreme Courts. And then you can appeal all the way to the Supreme Court from either side, from either federal or state side. And that's because we have federal laws and we have state laws. Someone who is caught drunk driving, for instance, that is usually a state law. And so they'd be in state court and they have to appeal all the way up through state courts. On the other side, that example of the person that was protesting outside the park and got their sign stolen and got arrested, that's a federal violation. That's a violation of the Constitution. That's a violation of the First Amendment to the Constitution. So they would bring their case in federal court. And again, this gets really complex about which court to go to. And that's one of the things you learn in law school is how to bring a case and where to bring it. And it can be really complex, but it can also be kind of fun. It's like a puzzle about figuring out where to bring the case. All right, I promise we're going to get to the important Supreme Court cases in a second, but I just wanted to wrap up the three branches and show you what checks and balances looks like. So here we have our three branches. The powers of each branch are written underneath. So the president carries out the laws, Congress makes the laws, Supreme Court interprets the laws. And then you can see where these arrows are. There are all kinds of checks. So we just talked about the judicial branch. They can declare laws unconstitutional. They can also declare executive actions unconstitutional. So really, really huge power there. Whereas the president gets to appoint Supreme Court justices, really important power there. President can veto laws. Congress makes the laws. Congress gets to approve Supreme Court justices. It goes on and on and on. It might seem like a crazy convoluted system, but it works if these branches are doing their job to limit government. Again, going back to those principles of government, one of them is limited government. And we and the founders, they didn't want government to move really, really quickly. They wanted things to slow down. And they've succeeded in that. It can be really hard sometimes to change laws. It can be really hard sometimes to get a justice put on the court. It can be really hard for the president to pass his or her legislation. So this is why the system is set up this way. Before we get to Supreme Court cases and the Bill of Rights, any questions on checks and balances? All right. So first 10 amendments to the Constitution were called the Bill of Rights. They were added because the political party known as the Anti-Federalists, they thought that the Constitution was giving too much power to the federal government. They wanted to limit it and they wanted it to be written down in there. So that's why they created the Bill of Rights. These rights protect our individual rights. At first, the Bill of Rights only applied to the federal government. It's every amendment would start with Congress shall make no law. So it only applied to the federal government, but now they apply to the states as well. Let's look at the most important of them. So First Amendment, I've talked about this already, but it protects free speech. Many, many people say that the most important right that we have is free speech, because even if we lost every other right, we could win them back with our speech. If you take away our speech, then our constitutional system and our democracy would fall apart. The First Amendment also contains the freedom of the press, the freedom to assemble, and the freedom to petition the government for redress of grievances. It also, and very importantly, protects the free exercise of religion, so that the government can't stop you from practicing your religion, no matter what it may be. And it prohibits the establishment of a national religion. So the government can't say only one religion will be practiced here. Second Amendment. Second Amendment is the right to bear arms of a well-regulated militia. Fourth Amendment. This is a constraint on law enforcement. It prohibits illegal searches and seizures, and it requires a warrant showing probable cause for a search. The founders, they put this in because British soldiers would come into their homes without a warrant. they would search and seize their property. And they knew that when they were creating their own form of government, they did not want to allow the police or the military to be able to do that. The Fifth Amendment, this you might have heard before. I'm pleading the Fifth, right? I'm exercising my Fifth Amendment right. It prohibits self-incrimination. It means you don't have to speak. You don't have to incriminate yourself. It's also heard in the Miranda rights. You have the right to remain silent. That is part of the Fifth Amendment. And then there's also a double jeopardy clause, meaning you can't be tried twice for the exact same crime. Sixth Amendment, it allows for the accused to have an attorney, very, very important, right? And to question witnesses against them, the right to confront witnesses against them. And then finally, 10th Amendment, any powers that were not given to the federal government in the Constitution are meant to be reserved for the states. This goes back to federalism. Questions on the first 10 amendments? I know there's a lot in there, but there's some really important stuff here. If you're interested in criminal law, the Fourth, Fifth, and Sixth Amendments are where you would be becoming an expert in. Again, in law school, that's what you'd be focusing on is those amendments. If you're more interested in First Amendment law and constitutional law, you're probably going to be focusing more on the First Amendment and then the 14th Amendment, which we're going to talk about in a second. Okay, other important amendments. The framers, they allowed the Constitution to be amended in one of two ways. You might be wondering, how do amendments get passed now? How can we do this? So first way to amend the Constitution is you need a 2/3 vote of both houses of Congress, both the Senate and the House. And then you need 3/4 of every state to ratify it, of every state legislature. So really, really hard to do that. Second, a national convention can be called by 2/3 of the state legislatures. So 2/3 of the states can get together and say, we want to have a national convention about a new amendment. And then they need to get approval from 3/4 of the state legislatures. This is rarely seen and rarely done because it would be hard to get 75% of the states to agree on anything. But if you could do that, you could amend the Constitution. Now, the Constitution has been amended 17 times after the Bill of Rights. Here are some of those most important amendments. 13th Amendment, right after the Civil War, ended slavery, massively important. 14th Amendment, again, after the Civil War, it requires equal protection under the law for all persons in the US. This has been used thousands and thousands of times to protect minority rights in America. Many people argue that the Constitution was not full until the 14th Amendment was passed. It was not a fully realized document until the 14th Amendment was passed. This is what actually made it a real democratic representative government document. And then finally, 15th Amendment, this gave African-American males the right to vote after the Civil War. You notice that women were not included in that, and they were not given the right to vote in America until the 19th Amendment was passed in 1920. This gave women the right to vote. Any questions on these other important amendments? Okay, so I promised we were going to talk about important Supreme Court cases. Here they are. First, Dred Scott, super important case. This is widely seen as one of the worst decisions in American history. It said that slaves, at the time slavery was still legal in many states, it said that slaves, even former ones, slaves that were given their freedom or escaped, could not become US citizens and therefore had no right to sue in court. This terrible decision was eventually overruled by the 13th, 14th, and 15th Amendments. Another terrible decision just as bad as Dred Scott v. Sanford was Plessy versus Ferguson. Very, very famous case in 1896. It involved a man who got on a train and wanted to sit in the whites only section. He was Black, and he was told that he couldn't sit there. This case reinforced the idea that it was okay to have separate facilities if they were equal. So it was okay to have a white's car and a black's car on a train. It was okay to have a white's bathroom and a black's bathroom on in a restaurant, and et cetera. And now this went on for almost 60 years, right? This was one of, if not the worst decision in American history. That got overruled famously in Brown versus the Board in 1954. This decision says that separate facilities based on race can never be equal. It was a school decision. They were a young girl named Linda Brown lived right next to an elementary school that was for whites only. She was forced to take a bus miles away to go to a school that was for blacks only. Her mother, her father, and the NAACP, including famously Thurgood Marshall, who was an attorney at the time for the NAACP, sued the Board of Education of Topeka, Kansas, and they won. The justices, in a unanimous decision, a 9-0 decision, said that Linda Brown could go to the white school, said that all schools that were segregated based on race were unconstitutional under the 14th Amendment. It did not change things overnight, though. Famously, in another case, the Supreme Court said that schools had to integrate, quote, with all deliberate speed. And now that phrase, with all deliberate speed, was interpreted by many southern states and many northern states as well to mean not to integrate at all. And a lot of what happened over the next 20, 30 years were battles fought in individual states over integrating schools. Another terrible decision in World War II was Koromatsu versus the United States. This decision said that the internment of Japanese people during World War II in America was constitutional. This case is one of the darkest days in American history, and it shows that during wartime, sometimes the people who are meant to uphold our constitutional system sometimes make very bad decisions in the name of national security. In 1973, Tinker V Des Moines, very important case for students' rights in school. This is probably the most important case about student free speech rights. It says that students do have free speech rights in school. That had never been said before. So students do have free speech rights in school unless they are causing what's called a material and substantial disruption to the learning environment. The kids in Tinker were wearing a black armband protesting the Vietnam War. It did not cause a material and substantial disruption. And so the Supreme Court sided with them, said they had that right to protest the Vietnam War. And then finally, Miranda v. Arizona. This is the case that has resulted in Miranda rights being read to people who are getting arrested. If you've watched any TV or any movies over the past 10, 15 years, I'm sure you've heard the Miranda rights read one way or the other. All right, questions on these? We're going to have to wrap up soon. Hopefully there's some good questions on Supreme Court cases.
Are Supreme Court cases easy to be like overruled?
No, they are not. And so in our judicial system, there is a doctrine called stare decisis, S-T-A-R-E D-E-C-I-S-I-S, stare decisis. What that doctrine means is let the decision stand. It's a piece of Latin. Again, if you go to law school, you learn a lot of Latin. And the idea behind this doctrine is that once the Supreme Court has ruled on something, we don't want to overturn it unless there's something really, really big that's changed in our society, or it was really, really obvious that it was a bad decision. And so that's why sometimes it can take 40, 50, 60 years to overturn a decision like Plessy versus Ferguson. There were definitely people at the time who knew it was a bad decision. There was a Supreme Court justice at the time named Justice Harlan, who dissented from that decision. He thought it was a bad decision. He wrote down all the reasons why in his dissent. And the framework for that, from that dissent that he wrote in 1896 is very similar to what the court said in 1954 when the case was overruled. So he turned out to be right, that they should have decided differently. It just sometimes takes a long time because of this doctrine, stare decisis. And there's a good reason behind it. It's because the court doesn't want to have to every year make the same decisions over and over again. They want to settle something and then move on to the next thing. The problem is when you have a case that's really, really decided poorly, then it can be hard to overturn it. Any other questions on Supreme Court cases? I'm just gonna, before we end, I do see some questions in the chat that I missed, so I want to hit those. There were some on New Jersey versus Connecticut plan. Yeah, New Jersey versus Virginia plan. That was the Great Compromise. Senators have no term limits. They serve every 6 years, but they can serve as many as they get elected. Yeah, there's no limit. Somebody was enjoying House of Cards. Oh, Third Amendment. Yeah, I just skipped it because it's pretty minor. It's actually kind of interesting. The Third Amendment prevents soldiers from being quartered in civilian homes, and that was a direct response again to the British putting their soldiers in the homes of the colonists at the time. And so the framers were saying, no, we're never going to allow soldiers to be forced to be quartered in homes. So if anybody ever comes up with that idea, if a congressperson, you can immediately say to them, that's wrong. That violates the Constitution. You can't force soldiers to live in civilian homes. Fantastic. Okay, so we've run over time here. There were a few more slides, but I'm gonna end things here, and I just want to see if there are any questions before we fully sign off for tonight. This has been an awesome session. Your questions have really made this worthwhile.
What are some aspects of the United States government that people are pushing to change?
So the biggest reforms that I've seen are around trying to change the Electoral College to make that a straight popular vote. That's one. Two, to change the composition of the Supreme Court. There's a big movement to either increase the amount of justices on the court or to put in term limits for justices. So rather than letting them serve for life, requiring that they leave the Supreme Court every 12, 14 years. There's also a movement to increase the amount of political parties that are part of the system. We didn't talk about political parties, but as you probably know, there are only two main political parties in the US, and it's very hard for third, fourth, fifth parties to gain any traction. And that's unique to the American political system. In other countries, it's a lot easier to do that. And that's because we have what are called single member districts, meaning that and winner take all elections, meaning that only one person represents a district. And so even if they only win 51% of the vote, then they get the seat. So there could be 49% of people in that district who hate their representative and they have no representation in Congress. So those are just some of the reforms that people are trying to make.
I saw in the previous slide, I don't know if I was misreading this, but can a Supreme Court justice impeach another Supreme Court justice?
No, they can't. That would have to go through the same process as impeaching the president. That would have to go through Congress, and they can only be impeached for what are called high crimes and misdemeanors. So you can't impeach a Supreme Court justice if you don't like their decisions. It would have to be if they committed a crime, essentially.
Okay.
Good question. Someone had a good question about the 14th Amendment. I want everybody to hear this. They asked, does the 14th Amendment also include immigrants or people that are not immigrants but aren't American as well, but live in the US? And the answer is yes. The 14th Amendment doesn't just protect US citizens, it protects every person in the United States, regardless of their citizenship status. And that's really, really important. There was a famous Supreme Court case that dealt with whether children of immigrants in the US who are here illegally could still go to free public school. And the Supreme Court said, yes, they can. The Supreme Court said that their 14th Amendment rights were protected there and they could still go to public school. So, yep, 14th Amendment applies to everyone living in the US. Doesn't matter if you're a citizen or not. You can't get, and that's very important because we wouldn't want to be treating people unequally based on their citizenship status. Any other questions before we sign off for tonight? Okay, so I really want to thank everybody for coming. Your questions made this session. I love the way you're thinking about this stuff. If you're interested in the legal aspect of things, I'm going to be holding sessions on specific Supreme Court cases as they happen. The court is going to start up their spring term really soon. There's going to be some really fascinating, interesting cases, including a very important case on affirmative action in college admissions. And we're going to be talking about those in sessions like this, where we'll actually listen to some of the arguments and get to talk about it. So if you're interested in that stuff, I call those sessions courtside. We'll be sending out emails about them. You'll get notices. The first one will be in about a month or so. But if you like tonight, please join our next session on the Supreme Court. Besides that, if you have any other questions or feedback, feel free to email me, just nick@civicsunplugged.org. And I'll see you all next time. Have a great night. Bye.